Good evening and welcome. At this time, we will call to order this special meeting of the Grand Forks School Board. First item on the agenda is the Pledge of Allegiance. We'd ask that you stand as you are able. Direct your attention to the flags in the southeast corner of the room. The single item on the agenda this evening is the Level 4 grievance appeal by Mr. David Christensen. At this point, we're going to hear the appeal. I'll turn this over to Rachel Bruner.
Thank you, President. For those of you that don't know, I'm Rachel Bruner. I'm out of Bismarck at the law firm of Pierce Sturrock, and I represent the school district, you all as a board. What's being handed out right now is a packet of information that I'm going to go through with you guys, but go ahead and open that up, and there's a table of contents after the agenda. I'll just kind of wait till everybody has it. Okay, so there are eight items. We're going to kind of go through 8 documents here. The first is the policy itself, 4120. If you want to take a peek at that first, and I'm not going to go over this verbatim, obviously, but I just want to highlight a few things. On the first page of policy 4120 in section 2 definitions, it defines a grievance as an event or circumstance for which a teacher feels dissatisfaction and chooses to communicate the concern to his or her immediate supervisor. However, a grievance must be directly related to the terms of the teacher's individual contract with the school district or a concern related to the terms of the negotiated agreement between the school board and any officially recognized teacher representative organization. A grievance must be in writing, give a clear and concise statement as to the specific provision of the negotiated agreement or contractual provision involved, and must state the relief sought. And then on the second page of that policy, this is where we're at. Section 2, the grievance procedure. We're at E, level 4 is what we're doing today. So in the event the grievance is not resolved in level 3, which here it wasn't, and I'll go through that, the decision rendered may be appealed to the school board, provided such appeal is made in writing within 5 days after receipt of the decision in level 3. If it's properly appealed to the board shall set a time to hear the grievance within 10 days after receipt of the appeal, and then within 10 days after the meeting, after today's meeting, the school board shall issue its decision in writing to the parties involved. And I'll go over that at the end as well and remind everyone of those deadlines. But that's what we're doing here today. There is no formal hearing process. This isn't a process spelled out in law by any means. It's only in your policy, so it is going to be relatively informal. What I like to do for teacher grievances when I'm involved is that I kind of go through and discuss the background a little bit with the board, and then go over the administration's position, because I'm here representing the administration as well. And then Mr. Christensen and his representatives absolutely should be given an opportunity to speak and discuss why they disagreed with the superintendent's decision. And then if the board has questions, you guys by all means should be able to ask and be free to ask. I would just advise that if you have any questions relating to legal advice, save those for the executive session, which we'll kind of talk about during then. But if you have any questions as to the facts or why X, Y, and Z was decided that way, by all means, you should be able to ask questions during this process as well. And then we're not going to cut anyone off unless something's inappropriate or comes up that discusses something that shouldn't be, but everyone should be given as much time as they'd like to speak. Okay? With that, I kind of just want to go over the background with you all, and that's where we'll get into all of these documents. So, Exhibit B is the teacher negotiated agreement. You guys have all seen this before, I assume, but what I want to highlight is the extracurricular schedule. So if you go to the end, you have one for 23-24 and for 24-25, and the first page of the schedule for both 23-24 and 24-25. Has instrumental music as a position, and has pep band performance as a position. So I just want to highlight that those are in your extracurricular salary schedule that was negotiated with the board and GFEA. That will become important as we kind of go along in this, but I just wanted to highlight that. That's all I really needed out of the negotiated agreement. Exhibit C is Mr. Christensen's teaching contract for last year, the 23-24 contract. He held a full-time teaching contract last year for $75,192. He signed his teaching contract for last year on June 19th, 2023. And the important part here is I want you to note the assignment paragraph. The above-named teacher shall faithfully perform the services prescribed by the school board or its designated representative during the life of this contract for the annual salary indicated above. And said teacher agrees to perform services in the schools of said district, subject to the certification of said teacher as being legally qualified under the laws of the state of North Dakota and the regulations of the State Department of Public Instruction, it being agreed that no teacher shall be assigned to perform services which he or she is not certified. Okay, so there's his full-time teaching contract for last year. Exhibit D are his extracurricular contracts for last year. I pointed out those two things in the negotiated agreement in the extracurricular contract because Mr. Christensen held those last year. The first page of Exhibit D is his extracurricular contract for head director of music instrumental at Red River High School and the amount of payment he got for that. One thing to note is he signed this on September 11th, 2023. These are not issued at the same time as your teaching contracts. Okay, that's important, and I'll circle back to that in a bit as well. The other thing in these extracurricular contracts, you have a paragraph that talks about how the district can cancel this activity in its sole discretion. That's that longer paragraph in the middle there. Okay, the second page of Exhibit D is his extracurricular contract for pep band at 60%. And same thing, he signed that on September 11th, same date as the other one. And then there was an amount there, same language about the district may cancel it as well at the sole discretion. Okay, so that's Exhibit D. Exhibit E is Mr. Christensen's contract for next year, the 24-25 school year. It is a full-time teaching contract for next year as well. It includes the same assignment language as the year prior. And he signed that on April 16th, 2024. Okay. Exhibit F. This is something we are going to go over in detail because it's been brought up, but it's a letter of reprimand that Mr. Christensen received on June 20th, 24, regarding an incident on 5/31 and 6/2. And I am just going to read that verbatim. It's to Mr. Christensen from Dr. Arson, the principal at Red River. It says, "You have been employed as a band teacher and head band director at Red River High School since 2011. During the 23-24 year, your teaching schedule and extracurricular contract included," and there's a teaching schedule, and then the extracurricular duties. "On Friday, May 31st and Sunday, June 2nd, 2024, you and the assistant band director at Red River High planned and carried out 2 pranks to confuse and alter Red River High School's 2024 graduation ceremony. Below are the details of the 2 events. At graduation practice, the pace of the processional music was played fast and slow instead of consistent tempo, the way the music was intended. The assistant director was seen laughing while students, teachers, and principals were entering the arena during graduation practice. A student reported The speeding up and slowing down was practiced in school during band class. The goal was to mess with the processional. At graduation practice on May 31st, the recessional was practiced using Red River's long-used boom crash, which cues students to turn, and the honor ushers to start leading students, teachers, school and district officials, and the board members out of the arena. The boom crash is a long-standing tradition that's been used during Red River's graduation for the past 15-plus years. On Sunday, June 2nd, the symphonic band intentionally did not play the boom crash, signaling that it was time for the recessional to begin, leaving all graduation participants confused as when to leave the arena. A student reported that the assistant band director told him prior to the performance that he would not be performing the boom crash. On video, you, Mr. Christensen, and the assistant band director can both be seen laughing and looking at the stage as confusion ensued as to when to leave the arena. Following the graduation ceremony, I asked you about the boom crash, and you said, "Oh yeah, I guess we missed that," and then followed up by commenting, "I guess music matters," smiling as it was said. Graduation is a day to celebrate students for their 13 years of academic achievements, a day where we recognize all that is good and positive as we send our students off to the next phase of their life, a day where family and friends come together to celebrate their graduate. It is a momentous day in the lives of the 242 graduates at Red River High School and their family and friends. Unfortunately, on this day, you and the assistant director wanted to make a point about your dissatisfaction regarding the band reductions with the administration at Red River High School, Grand Forks School District Administration, and the Grand Forks School Board. You and your assistant band director planned and carried out musical disruptions to deliberately throw off the graduation practice and ceremony and used Red River High School band students to help you do so. It is noted that the musical disruptions were carried out by assistant band director. However, Mr. Christensen is the band director and teacher of record for the Red River High School symphonic and concert bands. The practicing of the processional music took place in your classroom during your instructional periods. Whether or not you actually conducted the musical disruptions or not, you are ultimately responsible for the bands under your supervision. In addition, you may not have told the percussionist to not carry out the boom crash, but you were aware that it was not going to happen as you were seen on video laughing and talking during the processional music. You had the ability to stop both of the musical disruptions, but chose not to. This letter constitutes a formal letter of reprimand for violation of the following core professional standards for GFPS teachers, as outlined in the Staff Code of Conduct Policy. 1, conduct oneself professionally whenever serving in their official capacity as a school district employee, including maintaining professional decorum and professional boundaries in all interactions with students. 2, exercises honesty and integrity when executing all duties. 3, treat all staff, students, and community members with dignity and respect. Dr. Arson met with Mr. Christensen on Thursday morning, June 20th, 2024, to review the incident and provide him a copy of this letter. Failure to conduct yourself in a professional and ethical manner constitutes a clear violation of the above expectations and standards. Consequently, you've been issued this written letter of reprimand, and a copy will be placed in your personnel file. Further incidents of similar nature will necessarily result in more serious disciplinary action, up to and including suspension without pay or even termination of employment with Grand Forks Public Schools. And it was shared with him on Thursday, June 20th. Dr. Arison signed, and Mr. Christensen refused to sign. The next page is a rebuttal that Mr. Christensen submitted on June 21st. It says, "This letter is in response to the letter of reprimand placed in my employee file on June 20th, 2024 by Dr. Chris Arison, principal at Red River High School. First, a few additions and one correction to my teaching assignment from 23-24. Under extracurricular duties, I conducted Jazz 3, Rider Jazz, not Jazz 2. Additionally, I supervised drumline, trombone, choir, and jazz combo, and also directed the marching band. In regards to the pranks, the graduation rehearsal processional prank was planned." So just note there, the graduation rehearsal processional prank was planned. However, there was no malice or intent to disrupt the flow of the processional, which in fact it did not. In fact, I saw no reaction from staff or the graduates themselves that they even noticed. We changed the meter from 4/4 to cut time twice, which made it sound as though the music sped up and slowed down briefly, but the beat never changed. This change of meter was simply an inside joke intended to put a smile on the band seniors' faces as they were processing in reminding them of the length and tediousness of the song for the instrumentalists. As mentioned, this did not in any way disrupt the flow of the processional during the rehearsal. This change was not replicated during the graduation performance. Regarding the statement where Dr. Arison claims I said, "I guess music matters," that is incorrect. I did not make that statement. That was the assistant director who was also involved in the conversation. Dr. Arison, myself, and the assistant director were well within speaking distance of each other. I believe Dr. Arison's recollection of who made that statement is inaccurate. I'm just going to pause there for a minute. We can kind of talk about that as well, and Dr. Arison is here if any of you have questions for him. But when I talked to him, and Dr. Brenner had talked to him when deciding the next level of the grievance, Dr. Arison is adamant, and you can hear from him yourself, that Dr. Christensen did say, "I guess music matters." Am I saying that correctly? Okay. The rebuttal goes on, regarding the rehearsal of the pranks. Yes, we rehearsed the meter changes for graduation rehearsal, but that did not occur at the ceremony itself, and no mention of it was ever made by Dr. Arison or anyone else after graduation rehearsal. Only now is this being brought up after the graduation boom crash incident. The boom crash prank, which signals when the graduates are to start the recessional, was never rehearsed. In fact, when I rehearsed the band, I made it clear how important that is and made sure it happened when it was supposed to at rehearsals in the band room. At graduation practice, when the assistant director was directing, the boom crash occurred when it was supposed to. When it didn't happen at the actual ceremony, I was as surprised as anyone. I didn't know in advance that there wasn't going to be a boom crash. Dr. Arison seems to be taking my reaction to what ensued, which was a 10 or 15-second delay to the beginning of the recessional, as somehow indicating prior knowledge. That is not true. My reaction was how I often deal with unplanned situations that arise often in musical performance, and that is to laugh or smile, to ease tension for the performing band members rather than become angry and upset. If I were to show anger or become upset, that would only make the situation worse for performers and would draw additional attention to the mistake. Therefore, my laughter that Dr. Arison refers to is how I reacted to what had just occurred. I did not have the opportunity to stop the musical disruption on June 2nd because I did not know what was going to happen. The rehearsal disruption was no disruption at all. No one stopped marching in, no one appeared confused as to what to do, and the rehearsal went on as normal. There was no harm done. I strongly disagree with the points of staff code of conduct policy Dr. Arison says I violated. One, I conducted myself professionally and maintained professional decorum and professional boundaries with students upon realizing a musical mistake had been made during a performance. 2, I did exercise honesty and integrity in executing my duties. 3, I did treat staff, students, and community members with dignity and respect. I don't believe I should be held responsible for another person's actions when I had no idea those actions were going to take place. So after the incident happened at graduation, Dr. Arison met with him. They had a conversation. It was discussed that Mr. Christensen was going to be transferred to the open elementary musical position. So he'll be at 3 elementary schools next year, and that he would not have the same extracurricular contracts. And that's included in the grievance when we get into the next exhibits, but there was discussions about that. I'd like this to come out of Dr. Arison, but during those conversations, did Mr. Christensen call you a name?
Yeah, and am I on? There we go. That was a phone conversation I had with Mr. Christensen. I called him on June 6th. He was out of town. I was getting ready to leave out of town. I called him to have a conversation with him and let him know I had learned what happened at graduation ceremony. At that time, I told him there'd be a formal letter of reprimand that would be going in his file and that he would be transferred. At that time, he said, "You son of a bitch." And I said, "Dave, I do not feel I can trust you to lead our band department. You were seen laughing on the video during that time." And there was quiet, and he said, "Well, I'm going to need time to discuss this."
Okay. And then you went ahead and issued him the letter of reprimand like you said you were going to.
Yep. So I was out of town. I was on vacation for an extended period of time. I told him that I had met with Dr. Brenner, Ms. Galatch, Mr. Gillespie, HR, and I said if he had any questions for them, he could direct the conversations to them, and that I would be in contact with him when I returned from vacation, which I was. I returned on the 17th. I sent him an email asking when would be a good time to meet.
Thank you. And then there were some questions in a meeting with Ms. Galach and Mr. Christensen, and I believe his NDU rep. Do you want to discuss kind of what happened at that meeting?
Yeah. So I believe when Dr. Harrison reviewed the file with Ms. Haskell, Mr. Christensen, they asked the question about the extra contracts, and we're concerned about those contracts not being issued with the reassignment. And so following process, Amber requested to meet with me, and we did that. At that time, Mr. Christensen and Amber brought in the letter that you just read, that was the rebuttal, and I just took that under advisement and read through it as well. It was the first time that I had heard that information, and shared with them at the end of the meeting, and I have notes that I can bring up to give more detail if needed. Shared with them at the end of the meeting that I would look into the extra contract piece, that I didn't believe at that time that that was the same circumstance that they were arguing as it pertained to some other contracts that we agreed to continue for next school year, that the circumstances were different because it was an extracurricular contract. And we left that meeting also that I reiterated the fact that there would be a reassignment to the elementary level, and that we would have a follow-up conversation after that. So at that point, I brought forth to Dr. Brenner and to Griffin Gillespie the concerns about the contract, reached out to legal, I think that was you, to see if our perspective on that was accurate, and got back the information that the contracts were not, they were separate. They were two separate entities, and Ms. Haskell and Mr. Christensen and I met again, and I shared that information with them, and from there they went forth with the going up the ladder to Dr. Brenner.
Right, thank you. So then there was some meetings with Dr. Brenner, and he kind of relays that really well and lays it all out in Exhibit G. So I'm again gonna, actually, since this is coming from you, Dr. Brenner, do you want to just read, so give my voice a break?
Sure, happy to, thank you. So this was a follow-up memorandum for relative to a meeting that I had with Ms. Haskell and Mr. Christensen. So I'm just going to read through it, starting with the first paragraph. Thank you for meeting with me on Wednesday, July 3rd, leading into the 4th of July holiday weekend. I note the holiday weekend as I'm counting the business days of Friday, July 5th, Monday, July 8th, Tuesday, July 9th, and today, Wednesday, July 10th, as responding to you within 4 business days relative to an appeal process defined under the school district's grievance procedure. See the outline below. While it was not noted within our conversation that this was in fact a grievance procedure, I am treating it as such, so there's structure to the process. Rachel, should I?
You don't need to go through that part.
Okay. Okay, thank you. So I'll turn to the page 2. On behalf of David Christensen, Ms. Amber Haskell verbally noted in our conversation the following, and these are my notes as a document was not provided to me. Red River Principal Dr. Chris Harrison called Mr. Christensen on June 6, 2024, and informed him of a forthcoming letter of reprimand due to an incident at Red River High School's graduation ceremony on June 2, 2024, a situation that, from Dr. Harrison's perspective, was something Mr. Christensen was either an active participant or knowingly allowed to happen as band director. What was not shared with me during our conversation was that the phone call concluded with Mr. Christensen calling Dr. Harrison a son of a bitch, quote unquote. Dr. Harrison was then on vacation for the next several business days. Dr. Harrison, and along with Dr. Darren Walters, who is an associate principal at Red River, was present, met with Mr. Christensen and Amber Haskell on June 20, 2024, and provided the letter of reprimand and confirmed Mr. Christensen would be transferred to 3 elementary schools. Mr. Christensen has denied knowing anything about the band prank, which led to the recessional confusion at the conclusion of the graduation. There is a discrepancy between Mr. Christensen's and Dr. Harrison's recollection of the conversation that ensued following the incident. Ms. Haskell provided a copy of a June 23, 2024 communication from recently resigned band teacher Janelle Huber, see attached, who took full responsibility for the prank and stated that Mr. Christensen had nothing to do with it, quote unquote. It's my belief that Mr. Christensen made a statement to Dr. Harrison, something to the effect of music matters, quote unquote. As Dr. Harrison stated in his letter, the overall supervision of the band falls under Mr. Christensen's purview. Ms. Haskell expressed concern that Mr. Christensen's other compensated duties are not accurately reflected in the letter of reprimand. That information will be corrected in the letter of reprimand. Ms. Haskell expressed concern that the Red River band position was posted prior to the situation being resolved. Ms. Haskell expressed concern that Associate Superintendent Catherine Galatch stated there was a lack of trust in Mr. Christensen. Ms. Haskell reported that Ms. Galatch stated that since Mr. Christensen has been actively pursuing positions outside of the district and in combination with other band teachers' resignation, it's time for a clean slate at Red River High School. In my conversation with Dr. Arison and Ms. Galatch, the trust factor is not independently tied to this situation, nor Mr. Christensen seeking employment elsewhere, but rather to other conversations Dr. Arison has had with Mr. Christensen, such as not allowing students to use Mr. Christensen's keys to access a bathroom in the dress rehearsal room. I'm on page 3. Ms. Haskell was concerned that this statement suggests teachers do not have the ability to seek employment elsewhere without retribution. The relief sought in Mr. Christensen's Level 3 complaint is, 1, Mr. Christensen remains at Red River High School in his present position. For item number 1 above, the request is denied. Rationale, the district may, under the certified voluntary and reassignment procedure, reassign a teacher. And then there's a part in there. Rachel, would you like me to read through?
You don't need to.
Okay, so we'll skip over the certified voluntary transfer and reassignment procedure. I'm on the top of page 4. The second matter of relief being sought. Mr. Christensen's additional contracts, which are separate from his teacher's contract, be paid even if he's transferred to elementary schools where he would not have those additional duties. For item number 2 above, the request is denied. Rationale, Mr. Christensen's teacher contract is independent of his extracurricular or co-curricular contracts, which are issued separately at the onset of each school year. As a result, it is the district's interpretation that extra or co-curricular contracts not being issued or reissued is not a violation of the teacher's negotiated agreement. If all of the additional uncompensated duties Mr. Christensen were a part of his teacher contract, which they are not, a different decision would be rendered. And then the enclosures are attached. You're welcome.
Thank you. So that was July 10th. And then the enclosure that he references is that letter from Janelle Huber. She writes that, I'm writing to say I was the one responsible for the prank at the RRHS graduation. I did it in response to my position being cut at RRHS and to get the attention of administration that has otherwise ignored us. Dave Christensen had nothing to do with it, and he should not be punished on account of my actions. I did the prank because I knew I was resigning and wanted to express my displeasure of how our band program has been slashed by the administration repeatedly for the past 8 years. After the ceremony, our principal, Chris Arison, came over to the band set up to ask us what had happened. Dave, having no idea I had done it on purpose, laughed it off and said he wasn't sure what happened and apologized. I looked at Dr. Arison and he looked at me. I told him that music matters. I said this because I wanted him to know I was responsible. He did not respond. That was the end of the conversation. Had I known Dave would be unjustly punished by these harmless jokes, of which he took no part, I would not have carried them out. And Dr. Brenner, you took that into consideration in your determination of the level 3 grievance, correct?
That is accurate, yes.
Okay. And you determined that Dr. Arison's recollection was more credible than Ms. Huber's?
That is correct, yes.
Thanks. Okay, the last exhibit is Exhibit H. This is the Level 4 appeal. This is the reason we're here today. It's issued to the board president. And the grievant is David Christensen, filed against Grand Forks Public School District. The subject is a Level 4 appeal. The issue pursuant to Grand Forks Public Schools Policy 4120, David Christensen is pursuing Step 4 in the grievance procedure in response to his denied appeal received from Dr. Terry Brenner on July 15th, 2024. I'll just note there was some emails back and forth as well from when Dr. Brenner issued his decision. There was kind of a request to reevaluate that, and he denied that, and so that's where they're coming up with that July 15th date. Mr. Christensen was notified on June 5th, 2024 by Dr. Chris Arison during a phone call that his extended contracts, I want to clarify that right off the bat, we all saw that they're titled extracurricular contracts, not extended, that his extended contracts were being terminated. For the 23-24 school year, Mr. Christensen's assignment as head director provides an extended contract of $99.9612. Again, it's the administration's position and my position as well that it's not an extended contract, it's an extracurricular contract. Mr. Christensen assignment as 60% PEP band director provides, again, they're arguing it's an extended contract and we disagree, of $24,2160. These duties are directly tied to and cannot be separated from his daily curricular duties. Because these duties are curricular in nature, the district's required to go through the non-renewal process outlined in North Dakota Century Code. And then they cite 15.1, 1505. And then they also cite two cases, the Coles and the Wenman case. And I'm just going to briefly touch on those in a minute. But then the appeal goes on. Mr. Christensen and Amber Haskell, North Dakota United Field Consultant, met with Dr. Chris Arison and Dr. Darren Walters on June 20th, 2024. At that time, Dr. Arison stated any issues related to Mr. Christensen's extended contracts, again, they're not extended, would need to be brought to his supervisors for discussion. Mr. Christensen and Mrs. Haskell met with Catherine Galach, Associate Superintendent, on June 24th, 2024. At that time, Ms. Galach stated she would need to discuss the extended contract issue with the school district's attorney. Again, it's not extended. A second meeting was held July 2nd, 2024. Ms. Galach stated it was the legal opinion of the district's representative, Laura Cobb, that the extended contracts were not subject to the non-renewal process. Mr. Christensen and Mrs. Haskell met with Dr. Terry Brenner on July 3rd. Dr. Brenner responded to the concerns outlined in this meeting on July 10th. That's the exhibit we just went through. At which time Mr. Christensen's extended contracts were denied. Again, they're titled extracurricular, and it's our position they're extracurricular. On July 11th, 2024, Mr. Christensen and Mrs. Haskell sent a proposal to Dr. Brenner requesting the extended contracts be honored. A response was received from Dr. Brenner July 15th, denying the request. The resolution they're seeking from the board is that, one, Mr. Christensen is seeking the district to pay the full amount of his extended contracts for the 24-25 school year, $12,848.76. And then the PEP band, how they came up with that number, and the head director, how they came up with that number. So that's the request that's in front of you today. That's the appeal. From Dr. Brenner's perspective, from administration's perspective, and from my perspective as well, the extracurricular contracts are not required to be offered to Mr. Christensen. He has no continuing contract right, in my opinion, to these extracurricular contracts. And coming to that conclusion, I want to point out a few things that I touched on a little bit before, but the negotiated agreement lists both instrumental and PEP band in the extracurricular salary schedule. That's a document that's negotiated between the board and GFEA, noting that those are extracurricular positions. Those were titled extracurricular contracts in the two documents as well. It's our position, both the board and the GFEA have already agreed they're extracurricular. The extracurricular contracts themselves include language about the district being able to cancel the activity at any time. This too shows there was no continuing contract right to these extracurricular contracts, and Mr. Christensen should be aware of that from the language in the contracts themselves. Another big point is he's still receiving a full-time teaching contract for 24-25. His teaching contract is not being reduced. The cases cited in the grievance actually support the superintendent's decision, in my opinion. The Coles decision held that teachers have no continuing contract rights to extracurricular contracts, and the Wenman decision held that curricular contracts, including extended contracts, have continuing contract rights. It is our position these are not extended contracts. It is very clear from the negotiated agreement and the title of the contracts themselves that they are extracurricular contracts. And then another thing to touch on is overall, Dr. Arison is adamant that Mr. Christensen was aware of the prank for graduation. You heard him tell it to you again, that it was rehearsed. He smiled when it happened and he did not try to correct it. He said music matters when asked about it. When discussing that he was going to get a letter of reprimand, he called his supervisor, Dr. Arison, an SOB in anger. That alone could be grounds for discipline up to and including discharge of his teaching contract. But instead, Dr. Arison reprimanded him for his involvement with the prank, and it was decided he should no longer be at the high school level and was reassigned. And his instrumental and PEP band positions, His extracurricular contracts would not be offered to him for the 24-25 school year. That was the punishment he received for his behavior. In my opinion, I deal with schools all day long, every day. That's my full-time job. Mr. Christensen was given grace, in my opinion, where he could have been recommended for discharge from his entire teaching contract. He wasn't. He got a reprimand, a reassignment, and no longer the extracurricular contracts that he was given last year. In my legal opinion, he has no right to those extracurricular contracts, and I agree with the administration to deny his grievance and not pay him for those extracurricular contracts. We could jump forward with Mr. Christensen unless you guys have any questions of me or the administration before that, or if you want to wait until the end. Should we go forward with Mr. Christensen? Is everyone comfortable? Okay. So, Mr. Christensen, if you or your representatives have anything to address with the board?
Yes, we'll defer to Mike Eierman on the phone.
Yes.
We got off on the wrong foot. Mr. Christensen didn't grieve his transfer. He's grieving the issue of extended contracts. It's really unfortunate that we have now spent almost 35 minutes of this hearing smearing a very dedicated educator to the kids in Grand Forks. It was absolutely unnecessary for any presentation of this grievance by the part of the administration to get into the letter of reprimand or the transfer, because he never grieved that. If you look at your grievance document, which I understand is document number G, no, that's Brenner's letter. H, there's no mention in there of the transfer. That was absolutely unnecessary. So let's talk about what the real issue is. The issue that he actually grieved. And that's the issue in regards to these extended contracts. According to the grievance document, he's seeking $12,848.26, which we believe are his extended contracts. You call them extracurricular contracts, we call them extended contracts. This is going to become a form over substance argument. The form that you want, that your legal counsel and your administration wants you to look at, is because it's been labeled extracurricular, it somehow magically turns it into an extracurricular activity. Well, we know from our experience, all of our experience, that extracurricular means things like football, hockey, track, other things like that. And the Grand Forks School District has issued hundreds of contracts over the years in regards to those. But when a music director or a music teacher gets extended contracts to teach additional music, there is no doubt that music is part of the curriculum in Grand Forks. and that when Mr. Christensen enters into those extra duties, it is not extracurricular. It's not hockey practice. It's not track practice. It's curricular. And therefore, the first error that your administration has made is they now have considered those to be extracurricular because they point to the extracurricular concept or provision of the negotiated agreement. That's form over substance. That is absolutely form over substance. So let's go to the basics. Teachers in North Dakota do not have tenure. They have a continuing contract right. And Ms. Bruner has told you that continuing contract rights don't apply to extracurriculars, but they apply to curriculars. The reason that she knows that, the reason she can say that to you, is because of two cases which I took to the North Dakota Supreme Court. I took the Coles versus Glenburn Public School District case to the Supreme Court in 1989. And in the Coles case, what they did with Kevin Coles is they took away his athletic directorship position, which was part of his curricular day. They also took away a basketball position from him. And they also, there's another plaintiff in the Coles case, and her name is Francine Kuznia. And they took away a volleyball job from her. And so when we took that case to the Supreme Court, we made some arguments about that. Okay? But in actuality, there are 4 cases dealing with the concept of non-renewal and the removal of curricular duties. Okay? The first one was Quarles, the first one was called Enstead. And that was in 1978. And then in 1982, there was a case called Quarles versus McKinsey Public School District. And when I read to you various portions of the law under these cases, I'm not going to give you my opinion. I'm going to tell you what the Supreme Court said. In Quarles, they had taken away part of her job, and she thought she should be able to go through a non-renewal process to save that job. And when the Supreme Court got that case, they said this: an adjustment of duties which results in a severe reduction in salary for curricular activities, the non-renewal procedures must be followed. It is apparent to us, that would be the Supreme Court, that salary is for most persons the most significant portion of a contract. To expect a teacher to accept or reject a contract with a severe reduction in salary in curricular activities without providing the teacher with a non-renewal hearing is to ignore the fact. It would permit school districts to accomplish indirectly without a hearing what it cannot legally be accomplished without a hearing. That's in 1982. So in 1982, the Supreme Court comes up with this concept of if a school district is going to make a severe reduction in curricular duties of a teacher, they have to go through a non-renewal process. That's in 1982. 7 years later, the Coles case comes down. And so as an organization, the NDEA at the time wanted to see what the Supreme Court thought about a severe reduction. And in Coles, 1/7 of his job during the school day was being athletic director. But it was 1/7 of his contract, and they took that away from him without going through a non-renewal hearing. Here's what the Supreme Court says. With regard to the athletic director position, it is apparent the district treated that position as part of Cole's teaching load, or it would not have reduced Cole's base teaching salary by 1/7 when it did not assign that position to Coles. We therefore declined to treat the athletic director position as an extracurricular activity. The athletic director position was so intertwined, their language, not mine, with Cole's curricular duties that we will not distinguish it from his curricular duties. Our view, a 1/7 reduction in Cole's base teaching salary accompanied the loss of his position as athletic director was a severe reduction in salary in his curricular activities. So it's when I understand your legal counsel's argument, your administration's argument, well, it's in the extracurricular salary schedule. He's teaching music. He's teaching music. But then more importantly, and here's the distinction, with regard to extracurriculars, the Supreme Court says, with regard to the coaching positions that Coles and Kuznia, the district was not required to follow the non-renewal procedures in removing those assignments. Those coaching positions are clearly extracurricular. Okay? So then, 2 years later, the Supreme Court then once again defined severe reduction again. Keep in mind that in the Coles case, it was 14%. Fern Wenman's case comes down. She was a counselor who had an extra month on her schedule. It was an extended contract, But she was doing what she did during the school year. For Fern Wenman, the Supreme Court comes in and says, we believe that and it was argued, when we argued that case at the Supreme Court, and this is another one that I argued in Wenman, the Supreme Court, the reduction in Fern Wenman's contract was 4%. Coles was 14%. Wenman was 4%. Here's what the Supreme Court said. We believe the severity of the reduction in salary must be viewed from the perspective of the teacher who suffers the reduction. If Wenman's 1990-91 contract had not been reduced, she would have received $24,839 rather than the $23,814 which she did receive. Wenman's salary is not at such a high level that a 1,025 reduction should not be considered a severe reduction. We conclude that Wenman's 4% salary reduction was a severe reduction, which required the board to comply with the non-renewal provisions of the law. After Wenman, I can say this because I was around in 1991. After Wenman, school districts, if they were going to remove curricular duties from teachers, they either got them to sign an agreement or they non-renewed whatever portion of that extended contract was there. But we never had a situation where all of a sudden a school district comes in and locks off curricular duties from a teacher until they did it in Grand Forks. So from 1991, the school boards understood that if you're going to remove any kind of curricular duty from a teacher, you better go through the non-renewal process. Well, of course, the non-renewal process requires a hearing, requires notice, requires a meeting, and requires notice by April 15th. Getting back to my position about North Dakota teachers don't have tenure, but they have continuing contract. And on April 15th, those teachers, every teacher in the state of North Dakota, unless they've been non-renewed or unless they've resigned or agreed to it, they are entitled to the same contract they had the year before. So on April 15th of 2024, Dave Christensen was entitled to his full-time teaching contract and his extended contracts because they are curricular. If you think for a second that a court is not going to say that an athletic directorship during the school day is curricular, if you think for a second they're not going to say that pep band and drumline and the other things he does during the school day are not curricular, you're just kidding yourself. You as a school board should know that music is a very important part of the curriculum in the Grand Forks School District. So, 21 years later, in a case that I didn't take, some non-member goes up to the Supreme Court, and in Lynch versus New Public School District number 8, here's what the Supreme Court says about all of the cases they've already decided. All of the cases in which this court has held that a reduction in pay triggered the right to a non-renewal hearing involved an actual reduction in the contract salary paid to the affected educator. That's in 2012. After Wenman, we didn't litigate cases about removal of curricular duties because we didn't need to, because the school board and the school board association figured it out that if they're going to remove curricular duties, they should do that. In this particular case, I listened to your legal counsel. We have a fundamental disagreement. A fundamental disagreement, except when she says that Wenman and Coles actually support the position, they don't. They're not even close. Dave Christensen's reduction is 14%. When you look at his total salary for 23-24, the loss of those extended contracts are 14.2% of his contract. That's exactly the reduction of Kevin Coles, but Kevin Coles set the bar for 2 years because 2 years later the Supreme Court lowered the bar to 4%. So that's where you're at. Your administration either didn't know about the law, didn't care about the law, didn't apply the law, or whatever, but now the board's in a situation where they owe Dave Christensen almost $13,000 because they blew the April 15th deadline and they didn't take it away from him before. It's that simple. So, as I indicated before, and I'm going to cut my remarks short, it's unfortunate, and if I could think of a better word, I'd use it, but it's unfortunate that the administration and your legal counsel went through all of the nasty stuff that involved the transfer, especially in light of the fact that Dave Christensen didn't bring that issue to this board. You can resolve this, and you're going to go into executive session, talk to your lawyer, and you should. But the difference between your lawyer's opinion and my opinion is your lawyer said, it's my opinion that Wenman says this, and it's my opinion that Cole says this. When I gave you the references to Coles, and Wenman, I read what the Supreme Court said. I don't care whether you believe my opinion or not. I cite to what the Supreme Court says. Dave Christensen's entitled to that money. Liking it is not the issue. Your administration blew the deadline, and now they want to punish him. They punished him at this meeting. It's time for the punishment to stop. The costs involved in this, because it's my understanding we can, after this, if you vote no, we can go to arbitration. And by the time you get done with all this, you're going to wish that you paid him the 12 grand you owed him. So I will be more than happy to answer any questions that you have on this.
Mr. President, if I could.
Please.
So obviously, this is a difficult and odd position for a school board to be in, right? When really there's legal arguments being made by Mr. Christensen, representative, who is a lawyer and has absolutely every right to speak to the board on Mr. Christensen's behalf. At least one of you is a lawyer, but I am the lawyer representing the district. I am the one advising the district, and we'll go into executive session and talk more about that. But just for everyone in the room's knowledge, including Mr. Geierman, I do very much disagree with Mr. Geierman's citations. His quotes of those cases are accurate. I'm not saying they're not, but his interpretation is very different from what those cases said and from what the facts are in this case. These are extracurricular contracts. The GFEA agreed they are extracurricular contracts by an extracurricular schedule. Not just sports are extracurricular. That Coles case, they reduced his full-time teaching contract because he was doing his AD duties during the day, and they didn't give him another full-time teaching contract. That's very different than what we're doing now. He is getting a full-time teaching contract for next year. And the Wenman case, she had a 1-month extended contract. That's not at issue here either. We're not doing extended contracts. And we can disagree, Mr. Geierman and I, until we're blue in the face. Ultimately, it's your guys' decision whether you think you should pay him the money or not. If you have any questions as to the facts of the case, I think that's appropriate to ask now. Mr. Geierman said, like, going through all of the background was inappropriate. I don't believe it was. I think it's all relevant for you guys to understand why he is not going to be offered those extracurricular positions next year. But if any member of the board has any factual questions for either side, we'd be more than happy to answer them.
Any questions or items for clarification from board members?
I have a few questions. Mr. Arison, I'd like to hear directly from you. Maybe just, you kind of talked a little bit about your phone call with Mr. Christensen, but maybe talk about prior to the letter of reprimand and then why the decision was made for the reassignment ultimately.
I think the decision for the reassignment has to do with trust, and that, band is a very public program that we have. And for that to happen at our graduation ceremony, which are our largest performance of the year, I just didn't feel that that was going to be good going forward. There were some other things that were mentioned in there in Dr. Brenner's letter that I chose not to get into, but that also led up to part of this decision. But I think in our biggest performance, where it's all about kids, for that to happen, I just felt that there was time that he wasn't the leader of our band department anymore. As far as the conversation leading up to the phone call, there was some discussions with colleagues, there was some discussion with students, and that's where I got the information that it was something that they practiced for the processional music, which then led to skipping our boom crash, which signals everybody to leave the arena and leaves everybody confused, standing on the stage wondering what was going on. So that was some of the work that was done leading up to that.
How long was Mr. Christensen assigned the extracurricular contract for? How long has he been the band director? I may have missed that.
I believe it's been since 2011. He's been at Red River High School. I'm not 100% sure of the year. I guess that would be an HR question, but I think he came in 2011. Thank you. Yep.
Okay. Is band a required part of the curriculum identified by DPI?
No, nobody's required to take band.
Are there other music or band programs that are labeled as extracurricular in the district?
So we have vocal music, and orchestra would be on the extracurricular salary schedule as well
In high school?
in high school and middle school. And I believe there's even a few things for elementary after hours.
And are all of the band activities after hours? Are there some during the day?
So he teaches during the day, and then that extracurricular salary is for the after 4 o'clock work, whether it be concerts or sometimes they go to EDC ensembles, they go to different competitions. So those would be some of the things that fall into that contract,
So
extracurricular.
the extracurricular contract salary is for after-school hours?
Correct, for the time they put in after school hours.
Okay. This might be a question for the attorney, but is there anywhere in our teacher negotiated agreement that labels the extracurricular contract as an extended contract?
No, it is clearly labeled an extracurricular salary schedule.
Okay. I didn't see any reference to the language that was used by Mr. Christensen to you on the phone in the letter of reprimand. Why wasn't that included?
I guess I chose to keep it to what happened at the ceremony, not conversations that I had with Mr. Christensen, not what was said, more of the actions.
That's all the questions I have for right now. Thank you.
Thank you. Other board members, questions or items for clarification? Bill?
Yeah, I just have one, and it's maybe for Dr. Brenner or what. I know the attorney for the Grand Forks Education Association said he's been around for 37 years. Well, I've been around for 29 years. So, but the one thing that I would like to, I'm just going to state is that in all of our contracts since I've been on the board, it's always been listed as extracurricular salaries throughout all the negotiations. And at no time has the Education Association or anybody come to the board that I can recollect that it be changed to extended contracts. I just would like to state that. Thanks.
Other questions or items for clarification? Then I believe our next step is to move into executive session. Is that correct? Am I jumping ahead?
No, you are correct. So then if somebody wants to make a motion.
So then at this time, I would ask for a motion to hold an executive session, receive the board's attorney's advice and guidance on the legal risks, strengths, and weaknesses of its decision for the Level 4 grievance appeal as allowed by North Dakota Century Code NDCC 44-04-19.1, 2 and 5, and 44-04-19.2. I'm looking for that motion from the board. It's moved by Bill and seconded by Joel. We'll now take a roll call vote on the motion.
Lunn is absent. Flynn?
Yes.
Palmesino?
Yes.
Larson?
Yes.
Clevin is absent. Gockler is absent. Anderson?
Yes.
Manley?
Yes.
Berger?
Yes.
That's 6 yes, 0 no, and 3 absent.
Motion carries. We will now, as a board and associated members, we will move next door for our executive session. We would anticipate adjourning the executive session and reconvening the open portion of the meeting at approximately 6:20, 6:25. We don't know exactly, of course, until we know how many specific questions our membership will have, but that's roughly the time frame. Apologies if we deviate from that. We might stick a head in and say, hey, we're not close to that, but we'll call it roughly that for now, and then we'll come back in to reconvene the open portion. So we'll take a pause here. You all do not need to go anywhere. as is sometimes the case, and we'll head out for executive session. Do you have something?
Just clarification, you're asking them to go to the faculty lounge.
Oh, that's my pardon. Evidently, we're asking members of the public to adjourn to the faculty lounge. Maybe that's just a spatial relationship piece for noise and listening and conversation. So if you wouldn't mind, there's a space dedicated for you, and we'll adjourn when the executive session is concluded. Thank you. The minutes will show that the executive session was adjourned at 6:37 PM. The public has been invited to return to the meeting room, and we are now back in open session. Did I misspeak on the time? Oh, I'm sorry. Let the minutes reflect the executive session ended at 6:34 PM. The public has now been invited to return to the meeting room. We are back in open session. At this point, we are on item 2, part 3 of our agenda, potential action on a level 4 grievance appeal. I would now be seeking a motion to either grant or deny the level 4 grievance appeal by Mr. David Christensen.
I would make a motion to deny the level 4 grievance appeal of Mr. David Christensen.
It's been a motion to deny the appeal by Joel Larson. Is there a second? A second by Jeff. Any discussion? Hearing none, we'll take a roll call vote.
Gockler is absent. Larson?
Yes.
Manley?
Yes.
Clevin is absent. Anderson?
Yes.
Flynn?
Yes.
Palmasino?
Yes.
Lunn is absent. Berger?
Yes.
6 yes, 0 no, 3 absent.
Motion carries. Do you have a clarification?
I do. Would the board like me to draft the written decision on behalf of the board?
I guess I'll look to Joel and Jeff first for an answer on that.
Yes.
Then I would just note that you guys will need to have either an upcoming regular meeting, or you'll have to call a special if you don't have one. But for my calculation, that 10 days would be, it's business days, so it would be August 7th. So we'd have to have that meeting to approve that written decision by then, or that would be the last day. So just, you can kind of coordinate that as you go, but I'm just throwing that out there.
And I do know that we do not have a regularly scheduled meeting before that date, so we would be looking for a special meeting. And we are adjourned.